Assalamu alaikum and very good morning from Lahore. Bismillahirrahmanirrahim. I am Dr. Javed Iqbal Khokar, Professor of Forensic Medicine and Toxicology. And now we are starting with law related to medical man. And this is the first lecture on this series. And this will be main concern of basic matters of law which are related to medical man. And we'll try to understand the medical legal concepts of law codes, and legal proceedings. So the contents of my talk will be that we'll be understanding what is forensic medicine, again, a basic definition of the subject, what is law, and what are various types of laws, as we know that they are common laws and the statute laws. And the statute laws can be civil law and the criminal law. And we'll also talk about the Shariat Ordinance, which was enacted in 1988. So forensic medicine, we know that this is a branch of medicine which deals with the application of principles of medical knowledge in the courts of law for furthering of justice. And these are known as medical aspect of law. And it also deals with the doctor-patient relationship, and these are covered under the legal aspect of medicine. That means we are conducting medically, but we are being governed by certain laws, statute laws. So regarding law and law codes, basically law is an attitude of the society. It defies a comprehensive definition that we cannot define law in a particular period because it means rules of actions, so it can be applied to all kinds of actions. And it ranges from scientific laws to religious laws, civil laws, international rules, rules of game, and so on. You name anything, they will be governed by law. So it can also be confined to the human actions only. When we particularly define, they are related with human actions. And law is nothing but reasoning. That what is not reasoning, what is not logical, cannot be law. So law can be defined as rules established by authority, society, or customs based on reasons. So the law on these bases can be divided into common law and statute law. The common law is any unwritten law, and this is based upon conduct, decisions, usage, and customs of the society. The community controls the conduct of an individual. So over a period of centuries, particular customs grew up, which are even still now used in the law courts. So the common law is applicable universally. About the statute law, it is a body of law in the written form. It's a written law. And this is enacted by a legislative body of representative government known as Act. Or it may be a decree by a ruler of the time, and then it is known as ordinance. It is written and codified law of the country. The statute law is of two types, that is civil law and the criminal law. The civil law is that law which deals with the rights of the citizen in a particular state or nation. It provides remedies for personal grievances of individuals or group of individuals. It does not concern with the community as a whole. And issues like industrial injury, poisoning, industrial poisoning, medical negligence, matrimonial laws, landlord and the tenant disputes, they are dealt with in this law. And the damage is compensated in terms of money. Whereas the criminal law, it involves crime and its punishment. So criminal law can be defined as that body of law which exists for better governance of the persons within the state. It includes all the offenses against the law. The prohibition of certain acts or omission, that is total, that it has to be applicable and accepted to all. It is to be observed by all. Its contravention is punished with fine, imprisonment, or death penalty, depending upon the amount of grievance or damage. The purpose of criminal law is to safeguard the interest of the community and maintain a proper law and order and peace in the society. So the interests of the community at large or public at large are superior in the criminal law. So the law can be common law, statute law, civil law, criminal law, and there are other laws also. The statute law can be subjected to change either by amendments by legislative authority or degree by a military person or by foreign invaders. As after the British invasion in Indo-Pakistan, they gave their own laws, and which continued even after the independence of Pakistan. So these inherited laws were not in conformity with Islamic principles. Now these laws have been revised in conformity with the principles of Islam. So for that, the Shariat Ordinance 1980 was enacted in 1988. And according to Islamic faith, the sovereignty over the entire universe, it belongs to Almighty Allah. And the exercise of this authority by the people of this country must be within the limits which are prescribed by Him. So the Shariat Ordinance 1988 was an attempt to declare Shariat as supreme law of the country and guidance for policy and lawmaking. Whenever a question arises before a court that existing law is repugnant to Sharia, the court shall refer the matter to Federal Shariat Court for the decision of the issue. One of the judge of this court has to be an experienced alim, which is well versed with Sharia. This law further provides authority for the appointment of muftis who are rendering assistance for the interpretation of Holy Quran and Sunnah to the Supreme Court and to the High Court. It constitutes Islamic Ideology Council, Federal Judicial Council, and a commission to organize the economic and educational system on Islamic lines. So the summary of this talk is that we have talked about what is forensic medicine, basic definition, what is law, what are various types of laws, common law and the state. And the statute laws can be civil law and the criminal law. And we'll also talk about the Shariat Ordinance, which was enacted in 1988. We've also talked about the statute laws, which is civil law or the criminal law. And we have also talked about the Shariat Ordinance, which was enacted in 1988. Thank you very much. Please subscribe.